I can't remember what to do next.
0, 1, 2, 3. Let's get started.
Oh, that's real good.
Ain't nobody stopping me.
Hey, I'm so impressed every time it works. It comes on. Oh my gosh, how are you doing, you beautiful tubers? We are here with my good friend, the talented, the beautiful Yola Yodels.
Yodels.
Your Yodels over here. That's just the way it has to be. It's just everybody gets the name, and it's not on purpose. It's just like that's what comes out of my mouth sometimes, and it's just like what, and then you know that's me in a crowd hollering for you. I think that's how it works. My wife, I whistle at my wife.
Oh,
So yeah, I
you
just
don't
whistle.
You don't yodel?
No, I do that. That's don't ask. It's so weird. It's so weird. How are you doing, Yoli?
I'm all right. Yeah, I'm a little tired. I'm okay.
How's the weather out there with you?
It's weird. It was freezing this morning, then the sun came out and it got warm, and then tomorrow it's supposed to rain. So I don't know. It makes my sinuses go crazy.
That's wild.
The barometric pressure. Yeah.
I saw a thing the other day about Southern California, and it's only because it was about Beijing, and it was like, something like they were showing a thing about how they were saying like how wonderful and great their air quality is in China. And they looked at the China index. And they said, okay, like America's always like Los Angeles, the smog, the air quality, everything else. And it was like, there was like 20, which is really good, I guess. And then like Beijing was like 180. I was like, yeah, it's not all that. I don't know. I don't know how the spectrums work, but just anyway, air quality. But I saw the California thing. I went too far. I need to shut up. I need to start over. What we should do is get somebody else to be an expert. So anyway. Listen, y'all, we're going to go straight into this and try to get everybody out of here. I don't want to be here too long, but it's this is actually, if you remind me, hopefully Shizzy's got his channel set up for tonight because I told him I'd dump everybody on him. He's the one that he told me about this, and I was like, holy cow, I didn't know about it. And then it's crazy down in Florida right now. So Yoli, what was the last thing you were on? Because we talk whenever there's something unique or strange about this case.
So we were on when the judge had finally said, no more, don't file anything before the April 3rd hearing. I've had enough of both of you. Bring your, and I think it was like, then he issued another order because somebody filed something. I think it was Bruce. And he said, bring your checkbooks.
That's right. That's right. So sanctions and you're meeting for sanctions. He did the judge did the Expedia. So I checked it out.
Yes.
And it costs the same to fly to Gainesville as it does to Pensacola, and you'll be here on April 3rd, bright and early. And so anyway, that's where we are. And then I think it was like, so there's nothing. I mean, because he said, I don't want any more motions. I want nothing else. And I was like, so there's nothing between now and April. Like it doesn't matter what Bruce files, whatever else. The judge says, I don't want anything else. And then, hey, T for 2, thank you so much for the memberships. Thank you, T.
Nice.
But it is, this is a have we gotten to that point yet where this is going to be the case where, I mean, I don't know. I've said before that it's almost like he wants to make a landmark decision, something that's taught in law schools. But I don't think that we're there yet. I think we're at what not to do.
Yeah. It seems like everything that this Bruce guy is doing is getting the judge upset, more upset, and the judge is probably upset even more now that he filed something on the eve of the hearing saying that he can't make it because of the judge. He's afraid of getting arrested.
Yeah. Well, hey, let's go over that. Hang on a second. Let me let's go ahead. What buttons do I push for today? It's why can't I think of it? Hold on. Sorry, I just had a brain fart. What's that screen? Duh. Oh my gosh. I really did hit. You just watched my brain pop. I figure I'm going to be on stream when just the big one hits. The big stroke hits me, and we're all going to be.
Oh no! Don't say that.
That's the extra little bit of love you get by being here. Maybe just be like you could go around the rest of your days and say, "Hey, I was on stream when the guy." I watched him just go screech to a halt. So this looks a little rushed, right? He has just everything. It's like he typed it out on his phone, maybe.
Well, this is the second one, right?
Wait, hold on. Maybe I have the wrong one. Yeah, you're right. All right. So yeah, there were 3. That's where I'm getting confused. Sorry. So let me stop this one, and we'll go to.
Oh my God.
What?
I'm reading. It was impossible for the undersigned to reserve whatever. And it's like you've had weeks to do this.
Yeah. Yeah, yes. Right, wrong one. Hang on. Boop. I wish I could keep up with my things. That's the wrong one. Boop. And then there you go. So this is the big one. And so we don't need I'm not gonna read all 23 pages.
Yeah, 23 pages.
This is the one that I thought everybody was talking about. And I was like, okay, what's happened here? So this was filed on April Fool's Day, the 1st. And it's this is his typical way of doing it. He's got the colon crack, right? Motion to vacate consent to magistrate under 28 USC 636 C4. I mean, I didn't bother to look this up.
No,
based on extraordinary circumstances, including fear of arrest.
And there's a footnote right there. Can you go down to the footnote just real quick?
Yeah.
It says the undersigned.
The undersigned had originally intended to file a preliminary notice of intent to file a motion under 28 USC 636 C4 and seeking its stay. But order number 118, footnote, threatens sanctions should counsel file anything prior to April 3rd, not deemed an emergency by the magistrate. The undersigned therefore expedited preparing this motion.
Yeah. So he's saying that he's not consenting to have this magistrate hear this motion on the 3rd. Yeah.
Magistrate has ignored the plaintiff's above quoted admission of abusing litigation to inflict a financial burden. Although it was read out loud in front of him, he has not addressed the issues of whether the extortion label was purposely misapplied to influence the exercise of jurisdiction, nor the plaintiff's apparent perjury in the affidavit about online posts calling me a child predator. The magistrate has also relied on. So then he talks about everybody picking on him and stuff, and
he's fearing arrest.
Yeah, where's the?
It's up at the top.
Sorry.
Right. I think. Keep going up. Okay, it says right there, but the immediate reason for this motion is the extraordinary circumstance that the undersigned validly fears being arrested by the magistrate during an ordered show cause hearing on April 3rd.
Okay, so that's the question I have for you. Now, when I saw stuff, I was like, I have no idea. I have no idea what's next. I can guess. I can.
Mhm.
And I started thinking about it. Uh, talked to my good friend Shizzy Wiznut, and he's like, "Oh my gosh, have you seen the latest?" I'm like, "Dude, I don't even know what's going on." And I said, I told him I was reaching out to you. And he's like, "Oh, good. I love it when you guys do that." And I was like, "Well, thank you." I was like, "I love having Yoli around. She classes up the place." And by the way, guys, if you aren't, Yoli's getting very close to 1,000 subs. If you could click that link of hers that's pinned at the top of the chat, make sure you are subbed to her. We want everybody to grow.
Thank you.
Hey, we're a pie factory here. It's not about everybody having a slice of the pie. Is that we don't stop making pie. So fears being arrested by the magistrate, and you kind of laughed a little bit at that.
It's well,
How do you right? That's a sovereign citizen argument.
Well, the magistrate is not going to arrest him. The court the feds would arrest him.
Yeah.
Not the the magistrate.
Oh, I didn't even think about that. Yes. The
magistrate doesn't go around arresting people.
No, they don't give you handcuffs in the judiciary.
No, they don't. He could direct a bailiff in the court or whatever they're called in federal court to arrest him, but I don't. I mean, that's absurd. That is, he has to have due process before he's arrested. So he would. That's just absurd.
So, okay, he'd be held in contempt. Right, and so that would be
by not appearing. Yes,
but no. Well, I mean, he's saying like, if I show up, you're gonna automatically hold me in contempt, I guess, and I'm going to be.
I'm not sure arrested. What he's doing by his being arrested. I don't know.
Just hyperbole.
It makes no sense. It's stupid. It's absurd.
And here's the other thing: is so if he's afraid to go for a hearing, how can he represent his clients? He
can't. And that's going to be a problem. And he is pro hoc vice, meaning he's not licensed to practice there. He's specially admitted, and the judge could just
for
revoke.
This case.
Yeah, the judge could just revoke his pro hoc vice. That could be a sanction. But think
about that.
His client, the defendant, would have to be heard as well if he does revoke or is planning to revoke his pro hoc vice, because I don't know who local counsel is in Florida for this Bruce guy. So he may say, local counsel has to take over. But yeah, that whole thing about being afraid that the magistrate's going to arrest him. Well, first he says he doesn't consent to the magistrate. Okay, so well, you don't. I mean, if you have a problem with the judge, you can get out of the court. But I'm not sure how it's done in federal court. But this argument not consenting is just going to go by the wayside. He's already consented.
Well, yeah, exactly. So he said, "I'll do this, for this person." But he's supposed to be doing it pro bono, and that's another question. Maybe it's too early for me to ask this question. But if you start as you take a case on pro bono, do you have to? And let's say at some point the defendant or plaintiff, whoever you're representing, at some point they get financially in a position where they can pay. Like, you don't have to stay pro bono, right? There's nothing.
No, and actually, as a matter of fact, it doesn't really matter whether you're pro bono or you're getting paid. You have to do the same exact job you would. Period.
Okay.
If you undertake the representation of a client, it doesn't matter whether it's the key is that they undertook representation of the client, so they have to perform. Doesn't matter if he took it pro bono, he still has to perform. If circumstances change and the plaintiff can or the defense can pay, the defendant can pay, then they pay. So it shouldn't make a difference.
Okay. Okay. Because that's something that I just want to clarify that. So,
Yeah.
all right. Thank you. But yeah, so this was the first thing that the judge is going to arrest him. And now, without reading the rest of it, because it's 23 pages, y'all. I mean,
It's hilarious. The fact that he thinks he's going to be arrested, but the other thing he says is that he's afraid of Jeremy's followers.
oh, is that in this one? Let's see.
It's in the same paragraph with the one about the arrest. Okay, it says fears it right there. Down.
Sorry.
Right there. Okay, it says
So he's being arrested by the magistrate. Killed by the fears.
Go ahead.
Oh, sorry. From the plaintiff's followers to show up in Pensacola to see Deuce Foreskin, the anti-Semitic nickname ascribed to the undersigned by the plaintiff on YouTube. How's that anti-Semitic? Be arrested as the plaintiff has been promoting ever since the magistrate's order was issued. The fear of arrest stems from the magistrate having threatened the undersigned with arrest prior to the plaintiff's live deposition on December 19th. What happens in December is not what happens today.
Well, I don't know what was going on December 19th, but presumably his behavior was so bad that the magistrate said, I'm going to hold you in contempt and have you arrested. Because that's the only time the magistrate would ever, I mean, if he was behaving so badly at the deposition.
So, yeah, did you see it by any chance? Or hear it? Or I guess read it. It's like 300 pages, and it's...
I mean, I skimmed through it. But basically, he's just saying that the judge is just ignoring him and ignoring the lies he alleges that Jeremy said. And
that's another thing. That's not up to I mean, that's questions for the jury, right?
Yeah, and then he says, like, what that statement right there. 1, containing an eggplant penis emoji was not even the undersigned's email, but a journalist sent to both counsel, to which the undersigned replied. What does that mean?
That's part of the I think the magistrate is like, you got like their emails, like the way they've been behaving in their emails to each other. Yeah. I'm like,
what the hell?
Hey, let me tell you what I learned early. The attorney I worked for, he had 1 sentence emails, and it drove me nuts. And I was like, oh, wait a second, he's smart. So anyway, he didn't have anything in writing. All right, let's see here. Okay, I'll tell you what. I mean, I'm not qualified to say it, but it seems very some of this stuff today seems narcissistic. But I'm not qualified to say that. I don't care. I don't care what it is. I don't even know what that is.
He just, this isn't serious. I mean, I can't take him, and well, to say the both of the attorneys, it's hard to take them seriously, especially Bruce. But you know, they're, like I said, they're hashing out their differences in court, which have, you know, they're insulting each other. Well, I don't know if the other guy, the plaintiff's attorney, is doing that so much, but you know, it's just dramatics, you know. And Bruce is now not wanting to come to the hearing, even though he was ordered to come. Yeah. And then he files that other motion saying, as an alternative, I couldn't make arrangements. So it's kind of like, dude, the judge already told you not to be filing all these motions. I mean, I think maybe the plaintiff filed somebody filed motions for sanctions, and he said, you could have done that in 1 motion. Instead, you filed like 4. So, you know, it's not going to fly. I mean, this judge has had it.
I think the plaintiff's attorney, so it's Randy's, like I think he let Bruce get under his skin, and he lost his cool for a little bit. And you know, I mean, because Yeah, I mean, we've all been
yeah.
there. You got stress, you got all this stuff happening. And I didn't really pick up at first. First a couple times you read it, it's like, okay, like he went after him in that email. And then it's like, but will there be a problem with that? You never, again, you have a respect for your colleagues. And
Well, yeah, even in the Koberger case, there were some emails that were attached to some as exhibits between counsel, and they were pretty much civil. I mean, they were adversarial, but not calling them names.
yeah.
I mean, not disparaging the other, and
Patrick, I was thinking about that earlier today. I'm glad you said that because it was Randy Shockett, the plaintiff's attorney. He said, why don't you act like an attorney? Stop acting like this and start acting like an attorney. And that was where you go back and you see and go, okay, I see where he lost his cool. That's what the magistrate's saying and stuff. Now let's go. Okay, so this next one, this was also filed by Bruce, and this is the one. It's 5 pages. So so much has happened so quickly. Like it's like,
and really, it's not necessary to read the whole other, 20 whatever pages.
No, the 23-page one.
It's just repetitive, and it's just basically blaming the judge why he can't
show up,
or he doesn't want to show up.
Well, no, I like that he's scared of the magistrate. The magistrate's going to arrest him. All right, so this one is
crazy. Well, this is the one where he says he has in the alternative probably, and again,
inability to appear.
He's filing.
This one was rushed too.
He's filing an extra motion.
He's doing what?
He's filing an extra motion, which the judge does not like. If you're going to file something, you have it on different grounds. One would be, I'm afraid of being arrested. 2, I couldn't get reservations or whatever. Oh my God.
I think we talked about that. It's like, watch, he's going to say next that he's upset that the judge didn't make the reservations, the plane reservations for him. Where he's the Expedia stuff. It's like, well, why didn't you just go ahead and book me the flight? I don't understand here. It's so absurd. It's gone. It's a clown show, It
is, and it's sad. Because you don't want to do this in federal court.
Thank you, Rennie.
Or any court.
Notice of defendant's counsel's inability to appear April. Just blank. So I'm busy April. And requested a side motion number 96 and show cause based on number 115. I mean, he's not even writing anymore saying, my motion to blah, 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 blah. And he says, 96 and 115. I feel like I'm making an order at a Chinese restaurant. You walk in and it's all in numbers. It's like you look at the pictures and you're like, did they take those pictures? I mean, where are these pictures coming from?
And this is a notice, and this isn't even a motion, actually. This is the notice to defendant's counsel.
Oh, look at this. Sprinkle says, I believe he has filed 7 motions from 325 to 42.
That's, it's he's going to be labeled a vexatious litigant is what's going to happen.
The defendants give notice that their undersigned counsel is unable to appear on April 3rd pursuant to order number 98 because it was impossible to make the trip and also because he fears for his safety and freedom if he attended.
There we go.
Okay, guys, let me speak a little bit on Yoli's behalf here because she laughed, and I want to say I know why. Because you're an attorney. No one takes you. You're the defenders of freedom. You're not. I've never heard of an attorney ever being scared of a judge. Well, I mean, let's not talk about judges. But still, this is not how this works. And if you're afraid, I love freedom. Freedom. That's I mean, this is the mom and apple pie, red, white, and blue works now. If you're using freedom as I am afraid for my freedom, you're not qualified to be You're not qualified to
Yeah,
represent in this
it's
case.
not well worded, and I don't know. I'm this kind of behavior is what gets people labeled vexatious litigants. I mean, I don't know if this Bruce guy has done anything else other than this, but I mean, he's not a I mean, he's not the one who filed the lawsuit, but he's certainly acting like a vexatious litigant.
Yeah. If proceedings are not stayed sua sponte in response to this notice and or pending the district judge's ruling on the defendant's motion number 123, and also, why is there a space here? There's not supposed to be a space with it, right?
Yeah.
Sorry. It's back. I'm back to doing the grammar stuff with him.
You have to apologize.
The defendants respectfully ask that their response in document number 115 be taken under advisement and ruling on the plaintiff's motion number 96. It's a countdown. 123, 115, 96. Oh, in the court's show cause order number 98. Oh, I'm sure if you go and you like start pulling documents stuff, it makes sense. But like,
No, it's
trying
just
to read this
tedious for the judge to go back and look at what document number 115 is. This is just, it's really going to piss the judge off. I don't know.
By the way, this is one of the funniest things I've ever seen. That's why I'm so excited about doing this. I was like, this is the first time I've ever been like, I'm lost.
Yeah. And, I don't know what's going to happen at the hearing, and too bad federal court doesn't live stream hearings. But I'm going to be curious to see what happens.
Yeah, evidently there's going to be a bunch of Hales supporters standing out front, according to the last document. It was impossible for the undersigned to resolve calendar conflicts, including client hearings, for which they'd be left unrepresented. But your client's being unrepresented now by not showing up.
Exactly.
Which could lead to disproportionately negative consequences for both the abandoned client and the undersigned.
The abandoned client.
This is a federal.
Yeah, there's.
He's gonna have to show his calendar.
Well, if he's not there, he can't show anything. If he's not there, unless he attached his calendar as an exhibit, but it's not. This is just sad, honestly, to see an attorney actually just filing things just to file them, and I don't know.
Yeah. It was impossible for the undersigned to resolve calendar conflicts, including client hearings, which would be unrepresented. Okay, I read that right. Let's see, what's the first? Okay, footnotes from up there. The notice is filed at the risk of sanctions for not being deemed an emergency. That's number 118, I guess, is the order from the judge. But the undersigned felt that this was the proper course, even though implicit in number 123 that the undersigned would not be attending. 123 is that last one. Is that 27 page? So he filed one, and then he thought he had to file another. So
this is this is what's crazy. The title of it is Notice to Defendant's Counsel, inability to appear April, and then it's also a request to decide motion 96 and show cause based on 115. So honestly, if I were the judge, I would be like, you know what? This guy's going to get sanctioned, and I might just revoke his pro hoc VJ status. And, the judge can also report him to the bar of Massachusetts if he feels that it's warranted. Now, the judge was being so patient in the beginning, but it's now.
See, all right. The undersigned also has family obligations that could not possibly leave. He cannot possibly leave behind for up to 3 days. Why is it up to 3 days? There was no possible way to make all necessary arrangements for his family members' needs to be covered in his extended absence. The undersigned's wife has a rotator cuff tear for which she requires the undersigned's assistance with many daily activities. Is he wiping her butt? Is that what he's saying? He has a wipe her
Could
butt.
be if it's her right arm.
He has a wipe her butt. He could just get her a bucket. Anyway, the undersigned's daughter would miss an important band rehearsal. Oh my gosh, dude. Like that is, dude, rehearsal is not, it's not like she's playing in the Macy's Thanksgiving parade. This is a rehearsal.
And you know what?
rehearse
The
all
thing
the
is,
time.
this isn't under the penalty of perjury, I don't think, unless he signs it under the penalty of perjury. But this means nothing.
Well, let's just see what else he has. He's too important to do. He's too important for his clients, Yoli. He's too important for his clients.
But at the same time, he's saying he has other clients that would be
They're more
abandoned.
important.
Oh no, they would be abandoned if he came to this hearing.
The
Also,
whole state of Massachusetts would fall apart. Kieran Reed may not have a trial if he leaves. Who knows? Who knows what could happen? Dogs and cats living in harmony. Frogs falling from the sky. Who knows?
and I'm sure at some point he was. I mean, he had to have passed the bar, and he's an attorney and all that. But something went awry here with him.
Oh, by the way, someone had said that his children are 21 and 15.
Mm.
The undersigned daughter missed upon band rehearsal and be significantly affected by her father's unavailability to bring her to school and pick her up. They don't have buses in Massachusetts?
Uber?
I mean, I hate to say this, like my mom, like when I would come out of school, there'd be one car picking somebody up. It was my mom. Like she did not want me riding a bus. Nowadays, nobody rides a bus. It's the weirdest thing, at least here around here. I'm available to pick her up, and for reasons the undersigned is not going to discuss here, other than to say that it prevents him from traveling to Pensacola. So he's got
a court order, dude.
The cost of the travel is also extremely burdensome and disproportionate for the defendant's pro bono counsel. Okay, so if he's saying he's pro bono right now, what if he accepts money, but he's saying he's pretty? Can you do the duality there? I mean, is there sanctions for that, or?
Well,
also, I don't understand. I'm lost on that for some reason.
Well, if he's getting paid and he's representing that he's pro bono counsel, he's doing it and I'll have to see whether he signs this under the penalty of perjury, because this would, like, when we do this, if there is something why we can't attend a hearing, we have to provide a declaration of the penalty of perjury that this is going on, this is why I can't attend. You can't just write it in a paper and sign your name, because it's not under the penalty of perjury. So I don't know what effect that the pro bono representing that he's pro bono counsel would have, but it could be a fraud on the court if he's getting paid, because he's saying that he's doing it pro bono and it's costly for him to travel.
So I just saw something here in the chat, and I want to point out, you don't get in arguments on the internet because the internet always wins. And I don't know, I have no way to back this up, but 3 Awesome Dogs here saying his wife is a yoga instructor with a torn rotator cuff and is scheduled to do a couple of yoga sessions. I mean, that's how people find all this stuff out, and it's just it's unbelievable. Now, I don't know anything about that, but if that's why you don't fight with the internet, though, because if you say something, man, they will find everything out about you from day to night. It's crazy.
Yeah.
All right. The undersigned apologizes for pro bono counsel, especially when combined with the financial impact on his law practice of being away for several days, adding to the already huge financial impact on his practice of litigating on behalf of the defendants who are indigent against an aggressive plaintiff and well-financed counsel. He spends a lot of time on YouTube channels, and he spends a lot of time filing frivolous motions, and now he's talking about the financial impact on his law practice.
This is just a rambling statement, and when I think Patrick was asking what's the difference in pro bono and contingency. So pro bono, you never get paid. You're doing it for free. Contingency is if you win the case, usually plaintiff's counsel's contingency. If you win the case, then you get a percentage from what's recovered as your fees. So you front the cost, but when the work is done and you get a settlement, then you get your costs back and you can claim attorney's fees. That's contingent.
One of the only attorney movies I've ever seen was John Travolta, A Civil Action. Is that what it's called?
Yeah. Mm-hmm.
That's pretty good. It's a good. There's a very good scene about a contingency.
Mm-hmm. You can't get too attached to a case because it'll make you go bankrupt.
Yeah. I apologize for any filings or contents of filings that have offended the magistrate or incited his annoyance. The undersigned has sought only to zealously advocate on behalf of his clients and does not believe that he has transgressed any professional rules of conduct warranting sanctions or revocation of his admission pro hoc vitae. So I think I think Matt's in here. I think he likes to project of what he wants, and I think that him including this may be. It's like, oh, I don't think anything warrants my revocation of this. I think he's trying to say, yeah, you can go ahead and revoke it.
Yeah, but he cites no law to what he's saying. I mean, there has to be law for why there's warranting sanctions. So if he has a case law that says that his behavior or similar behavior does not warrant sanctions, he should cite it. Otherwise, it's just his own mind and his own opinion without any basis.
Justifies the necessities, the expense and hardship of multi-day travel, or that has justified the turmoil of his personal life and practice since the filing of number 96 and the court orders that it incited. The undersigned's children's late biological father passed away while on a work trip in 2015 when they were 5 and 11 years old. The undersigned adopted.
That's sad, but starting out with that is like irrelevant, but it's sad that the father passed away.
Yeah. Well, still doesn't have anything to do with the price of tea in China.
Right.
That's what my mom always would say. What does that have to do with the price of tea in China? I don't know. They're 5 and 11 years old. The undersigned adopted them after marrying their mother. Any extended work trip taking their father away from home creates anxiety for them as a result of that experience, and its lasting impact has occurred when the undersigned was ordered to travel for the December 19th deposition of the plaintiff and ended up not returning as planned due to flight cancellations. That is gross. I'm sorry. That's just, I can't do it because of my kids. They may get anxiety. I mean, don't bring your kids into it.
He's just putting everything under the sun, and it's sad that he's bringing his kids into it.
The defendants believe it is obvious. Well, I just had another stroke moment. The defendants believe it is obvious that motion number 96 was intentionally contrived and filed by surprise for the very effect it had, and that, as number 115 demonstrates, the subject emails do not remotely justify sanctions. 96.1 was a litigation in a different case prior to its referral. 96.5 was a journalist email, not the undersigned. 96. Okay, I'm just going to stop right there. He's saying that these were other things. The fact is that you put them into the case in this court. Doesn't matter if somebody else said or anything else. If it is gross and absurd or anything else offends the court, you can be held. You're responsible for that. I mean, if the judge says don't do it, don't put in your eggplant emojis. Don't put in your eggplant emojis.
I know. Yeah.
96.3, 96.4 said polyurethane or whatever is an acronym for protractor of litigation and multiplication of proceeds, not an insult or threat. That's funny. 962 is the only one sent as counsel in this case that involved a semi-insult. You're endlessly ridiculous, which is the same insult from the plaintiff's counsel that appears in one of his nearly 40 emails in motion number 117. The plaintiff's surprise. Hold on. What was this motion supposed to be about? Again, what's he titled this? Notice of inability to appear and requested a side motion 96. Gotcha. The plaintiff's surprise uncertified motion. Now, did you catch this? Like he did that. He went all over the local rules 7.1. The plaintiff didn't certify the motion correctly and all that stuff. And
that was we talked about. That was the meet and confer requirement or something. I don't remember what it was, but it was a local rule. And he says the plaintiff's surprise uncertified motion. So I guess I don't know what he's saying there.
Well, he's trying to say that Randy put in something wrong because he didn't have this motion. But then since then, there's been like 4 things that were denied because Bruce didn't have that same local rule 7.1 certification in his motions.
Yeah, I don't know what he's.
For sanctions of the acronym polymop, having incited immediate multiple court orders, responses, additional filings, more orders, and an ordered live show cause hearing has become the biggest cause célèbre for plaintiffs' YouTube followers since the plaintiff's December 19th live video. He's talking about us. Immediately following his live deposition, reporting he magistrates threats, right? Reporting he magistrates threats of arrest towards the defendant's undersigned counsel.
And then he puts a link. Yeah. See, I'm not, this is like superfluous, and it's kind of sad to see that this attorney's kind of, I'm not sure what he's doing or what he needs to be representing his clients, not himself.
Ooh, that's a very good point. He is representing himself, is what it feels like. None of this multitude of proceedings might have occurred without the calculated non-certified number 96 being non-certified, being filed for surprise effect, and its lack of certification ignored and denying the defendant's motion to strike it for that reason. Documents number 100 and 102. Let's see. The court, magistrate, and district judge alike can take judicial notice of the use of these events to generate YouTube content for financial profit on the plaintiff's channel, What the Hales, and other channels profiting off the content generated by his litigation, as long as they propagate the plaintiff's claims and attack the defendants and the undersigned. I lose money when I talk about the Hales. I can talk about anything else, and I get bigger. It's crazy. It's crazy. That's why I'm like, this whole argument of his is, it's so, the one thing he does not understand is YouTube, and he has got it so wrong, and the way people are, the way audiences are, the way the system works and everything. It's just sad.
Yeah, it's sad. He's trying to make points in here that really just, the judge is not going to be interested.
No. Let's see what his footnote is here. Hang on a second. This one made me laugh. K-Dubs. This looks like dollar store motions. I love K-Dubs. Some are directly associated with the plaintiff, with him periodically appearing on their live streams to discuss this case, which boost their view counts. Please take judicial notice of YouTube channels That Umbrella Guy, Megan Fox Writer, Shizzy Wiznut, Veteran Nation, Squid Pro Quo, just a few of those profiting from the content content this contrived litigation generates, and all one-sided for the plaintiff. Hey, I didn't get hit. You and I, we skated through that. It doesn't talk about us. Wait, maybe we're not doing something right. I don't know.
No, you don't need to be talked about. I mean, this isn't. I mean, this is, YouTube exists for a reason. If they want to cover court cases, they can. You know,
Yeah. I mean, there's so many things. It's the new media. I mean, you see Elon Musk talk about that with Twitter a lot. Yeah, that's YouTube's been all over it for a lot longer. One channel, DUI Guy, is a Kentucky lawyer, Larry Foreman, who has profited from coverage of the plaintiff's legal cases and was involved in a fundraiser held live by the plaintiff on YouTube to raise money for the biological aunt of defendant Preston's adopted at birth daughter, who'd never met the child, to hire a law firm to file for a fraudulent emergency custody petition, a months-long content generating storyline on the plaintiff and other channels that serve to terrorize defendant Preston, with the plaintiff promising his YouTube followers that she would have her child taken from her. Mr. Foreman also frequently attacks the integrity and qualification of judges, including gratuitous claims of being biased and corrupt to feed narratives he is pushing for entertainment profit. What does this have to do with him not showing up?
Nothing.
Okay.
Nothing
So
at all.
he's just out there. He's just whining. He's having a temper tantrum.
Yeah, I mean, he's just whatever he feels or whatever he thinks he wants to tell the judge, he's telling him. And, you know, the real issue is you were ordered to come to court and you are saying you are not coming and you don't have a basis for it because you knew about this a long time ago. You say that he says that his threat, the judge's threat that he was going to sanction him if he filed a motion, that's the reason why he didn't file a motion. So now he's filed something, but he's just rambling on, and you know, it's just a long rambling document, and it reminds me of somebody who is like having well, I'm not qualified to say this either, but like I won't say it, but it just sounds like somebody who's disorganized in their thinking.
Ooh, I like that. Disorganized in thinking. But that's me. So
Well, that's me too, but not when it comes to work. I'm disorganized in thinking in other areas, not when it comes to work. And maybe the reason why I'm disorganized in other things is because of work, because I'm so focused on my work.
Yeah. It's funny. Like my wife always said, we had this cleaned up. What happened to your desk? And I was like, well, we had Friday night, and then like I don't know what happens Saturday. I'm like, where did all this stuff come from? And then it multiplies. Okay, this is not an attack on their First Amendment rights, but to show the true motive and purpose for this simple one plaintiff, two defendant deposition case. Oh, now he's mocking the judge's words. The judge said that this is a simple one plaintiff, two defendant defamation. Yeah, it's not a deposition case.
Oh my God.
Jeez, man, you don't mess up like that. That's just like
simple one plaintiff, two defendant.
I've been better riding on a men's stall on a truck stop.
I was thinking that it said that it's a simple one plaintiff and two defendant deposition, meaning the only depositions that are taken are going to be the plaintiff and two defendants. But no, it's supposed to be defamation.
Yeah. Having been initiated and turned into a spectacle it has by the plaintiff and his counsel. Dude needs a mirror. This should be a relevant consideration for the court to carefully examine the issues of the plaintiff's mislabeling of non-actionable statements as extortion and interposing a possibly perjured affidavit that non-existent online statements calling me a child predator that are constant ongoing to this day to invoke federal jurisdiction. So that's something else. What was it? Did we talk about that? Where, it's because one of their things is like, who saw the signs? And it's like, it doesn't even matter anymore as long as you had the intent of distributing the signs. And now they're being discussed about all over the internet. I mean, that there is the problem was why is it defamatory to call somebody a PDF file?
Yeah. I mean, I had a friend who was accused of that, and was not true, and it affected him a lot. So I get it.
Just crazy. In denying a 12B1 motion, the court didn't meaningfully examine. If you meaningfully examined it, Judge, you'd have seen it my way.
Well, ouch.
Whether federal jurisdiction was fraudulently invoked as part of a litigation for content enterprise. That's really what he's upset when he says they did not meaningfully examine. And then the content for enterprise, it goes on to that polyurethane thing, or whatever he calls it. He's upset that the judge hasn't acknowledged his new acronym.
It's, if he wants, well, I don't think that telling the judge that he didn't meaningfully examine something is a good move, but
no, you're either implying something, or you're either implying that they were just careless, or they aren't a qualified judge.
He's just making excuses.
Okay, when you write something and it's going to the court, just remember that bless you.
Sorry.
One more time for luck. 3 times is lucky. You make a wish.
Hold on.
There you go. That's awesome. We just saw a wish maker. Hey, Bad Duck, how you doing, buddy? Let's see. And deny a 12B motion. Court not meaningfully. Okay, exactly. The undersigned is. Do what? You okay? Are you gonna do 3 more? 1. Oh, we don't get to see if there's 3 more, but that's super lucky.
My allergy is because this weather's changing, and my allergies act up. It changes the barometric pressure in my head, and then I start getting runny nose.
That was yesterday for me, or day before yesterday. Let's see here. The 912B1 motion, court not meaningfully examine whether fraudulent vote litigation for content, entertainment purposes, expense of indigent defendants, and the court's time and resources. The undersigned is unable to attend April 3, also for the reasons that detailed in motion number 123 from the court's orders numbers 97, 98, 102, 103, 118. It appears the court acted precipitously in response to the filing of number 96 and was unwilling to consider altering those orders regardless of the lack of certification. The response to it filed by the defendants, number 115, on the glaring issue detailed on number 68, going directly to the improper invocation of federal jurisdiction by the plaintiff, now addressing number 103, denial of 12B1 dismissal. I need a whiteboard. I'm lost. I need to draw it all out, and even then, I wouldn't think I'd have it.
Yeah, it's like a flow chart of just nonsense.
It's a flow chart of doom, and that doom of misery. As explained in number 123, the undersigned legitimately fears for his freedom. So now he's what is it when it's he a political prisoner when you fear for your freedom being taken from you?
Yeah.
Well, I mean,
and safety.
Yeah.
This guy is something else.
Yeah, so cannot attend the place himself at those risks. He cannot put himself at those risks in good conscience with his family and clients depending on him. Well, it sounds like he gave up on his clients in Florida. If he'd done anything remotely justifying such draconian consequences just to be able to defend himself, number 103, preempting asking for a remote hearing in lieu of ordering multi-day travel, he wouldn't be risking whatever consequences there may be for filing this notice and not traveling from Boston to attend on April 3rd. Defendant President Cook by Bruce Maskin certification. I hereby certify a copy of the foregoing was emailed to the counsel of record.
And he didn't sign it under the penalty of perjury. So all this stuff that he's talking about, you know, with his kids and everything, it's not signed under the penalty of perjury. So we, you know, you can't. Hold on, I need to get a tissue. Jeez, sorry.
Okay.
Sorry.
Yeah, take your time. No, you're fine. You're fine. Man, that's it's big stuff here. Hey Harriet, how you doing? Say hello to some of y'all people. Some of y'all people. Not all y'all people, just some of y'all people. John Gold. John, why did I get stuck on your name? I really do think maybe I had TIA or something. I'm having a hard time. What I'm upset about is I didn't finish mowing the yard. I'm gonna get in trouble over that one. Betsy Weingartner. Weingartner. I said last time I wanted to say Weisgardner, but that's okay. At least I'm carrying over my silliness. T42, how you doing? Shane Reynolds, Freckles, Noel Perry. Sorry, I was occupying saying hi to people because that bothers me. I like to say hi to everybody. Funston, Denise C, and that's T42 again. Okay. So that's his last thing. He sends it in, and that was sent in today, right? I believe.
Yeah, and you know, Rena Vilma.
No, it was sent in yesterday. The second. You know, that's today. He filed that early today.
Yeah. So one of the chatters, Renee Vilma, says maybe he's trying to get kicked off of the case. That could be. I mean, but what a way to do it.
I mean, why wouldn't you just say, look, I'm not going to be able to represent him? Hey, Krista, how you doing?
Right.
Just say, I can't represent him. It's overwhelming. It's, you know, I messed up.
Yeah.
Fregel says, hooked for phonics worked. Hooked on phonics, not foot. I can't read. Hooked on phonics worked for you, indigent. Oh, did I say it right? Oh my gosh, what's the what do they?
Oh my God,
I've heard it called I can't remember now. Why don't sharks attack CK lawyers? What's a CK lawyer? I don't know. Professional courtesy. There was a TV show named Shark with what's that guy's name? A cool guy, James Woods. I like that. Shark. Yeah. Indigenous. A lot of people read indigenous as indigenous. I'm like, no. All right, let's see. All right, so now after that was filed today, and that's when I asked you about coming on, because I was gonna say, okay, so he's not gonna go. This is what I wanted to ask. I was like, so my mind's blown. Like, how do you tell the judge all this stuff? Like, well, I have to take kids to soccer practice, you know, or I've got to do this. I've had all this time to figure all this out, but now I just can't do it. And when I'm scared I'm scared you might arrest me, and I'm scared that there might be Shizzy Wisnut may be out front. How can you be scared of a guy named Shizzy Wisnut? A little small, a little short guy, like a little leprechaun. Rub his belly, you get a pot of gold. But how do you go from that? Okay, so you file it. You said, all right, I'm hitting send. This is going to court. I'm not going to show up, and the judge is just going to have to deal with it. So what is, at that point, if you're the judge, what do you say? You know, I mean, what are the remedies available to a judge?
Well, he can hold him in contempt of court for not appearing at a court-ordered appearance. He can sanction him monetarily for possibly not acting in good faith. He could revoke his pro hoc vice status. He could report the attorney to the state bar from where he is in Massachusetts. What else can he do?
See, my thing is, okay, so did you ever see the TV show Justified?
It sounds familiar.
It has about U.S. Marshals in Kentucky.
Oh, yes.
Yeah, I love Timothy Oliphant was the.
Yes. Oh,
I
yes.
love that show. I love Justified. And so anyway, all I could think of was well, you send the U.S. Marshals and you say bring them to court because U.S. Marshals are in charge of the security for the court system. They're the bailiffs.
That's possible. Yeah, it is the U.S. Marshals. It's possible, but he's outside of the jurisdiction. So I guess federal jurisdiction would apply. So maybe they could do that. But, I'm not sure about that. But that's definitely something that could happen. I just don't know if it will because of the resources for marshals to go out there and get him.
Well, see, that was my thing. Is like I wanted to ask you about that because then I started laughing. I was like, "Oh my gosh, it'd be justified, right?" And then I started laughing. I started like, "Did you ever see the movie The Fugitive?"
Oh yeah,
It was the one-armed man.
yeah,
That's all I could think of today was The Fugitive. Tommy Lee Jones was the marshal.
yes.
Yeah, I love the scene where like Harrison Ford's like, "I didn't do it," and Tommy Lee Jones like, "I don't care."
I love Tommy Lee Jones. Yeah, so yeah, that was a good movie. Yeah, but he committed a crime like they had alleged that the fugitive had unalived his wife or something.
Yeah, but then he left, but he escaped from federal court.
Yeah. So it's kind of like that guy that escaped. What's his name? I don't remember his name anymore. But he was escaped and he was in Pennsylvania and everybody was chasing after him.
There's are you talking about there was a Mexican guy they called the Spider or something?
Yeah,
He's supposed to be like
crawled up the
5'1".
wall.
Yeah, that guy.
What was his name?
Yeah. I don't know, but that was wild. I covered some of that. I mean, like they went out there like, "Hey, I got to report." This was like news station, like, "Hey, I got to report that the police they're over here in this section." And the guy sat there for like several hours while the police that all their lights and everything had rose. It was really an interesting man. Bad Duck says, "Sadly, the days of people using proper English are went."
Gone.
Good one, Bad Duck. That's a good one, brother. That's a good one. Oh my gosh. Okay. Let's see. So I contacted you and we just talked about the conversation I want to have. It's like, so what are the remedies now? What do we do and stuff? And because I have no idea. And I was like, the only thing I could think was like you start talking about it, you start thinking, well, could it be this, could be that. And I was trying to mow the yard, and that's when this came in, and I was like, "Oh my gosh, yeah, Yoli!" I was like, "We got new stuff. This is new stuff. This is crazy." And where's
I
my
knew this was coming.
little guy here? That's not it. Oh, there it is. All right, and I was like, United States District Court for the Northern District of Florida, Gainesville Division. Order. Excuse me. Excuse me. I had to go get my wife dinner and I didn't get to eat mine. So a little grumbly over here. This matter is before the court on defendant's notice of defendant's counsel's inability to appear April. I love it. And request to decide motion number 96. Oh, look, by the way, there's no space. It's amazing. Evidently, all you have to your qualification to be a judge is to be an attorney and then be able to write properly. Hey, just remember, Supreme Court, you only have to be an attorney.
Yeah.
And show cause based on number 115, not on document 124. That document was filed today. To the extent defendant's counsel seeks leave not to attend the hearing that was scheduled nearly 3 weeks ago for tomorrow, April 3rd, 2025, the request is denied. I got to get my little highlighter back. Hang on here, because that's just too good. Right? Where am I? Yeah. is denied. Look at that. I mean, dude,
Did he
sorry,
think it was going to be granted? I mean, seriously,
right? I mean, the way the action's like, oh well, surely you're gonna see it my way, but it's similarly to the extent the filing requests a continuance or a stay of the hearing scheduled for tomorrow. The request is denied. The hearing will go forward tomorrow as scheduled. Footnote. Yesterday, defendants filed a motion to vacate consent to magistrate. Think about that. I am filing a motion to vacate my consent to magistrate. I don't consent to you.
it's, oh my God. He
I'm
can't.
going to use that in an argument. I'm going to get an argument with White Rabbit. I'm going to say, I do not consent to you to argue right now. You have
I
to
do not
remove
consent
yourself.
to your jurisdiction. Oh my God.
Defense current motion makes reference to the possibility of a stay being issued by the district judge in response to document number 123. The court would note that no stay has been issued by the district judge, and merely requesting a stay does not excuse noncompliance with an order. Rauch diagnostics. Gosh,
Diagnosed.
surplus diabetic, and recognizing that the mere filing of a motion to stay does not excuse noncompliance with the order.
Exactly.
I mean, duh. I mean, you don't have to be an attorney to know that.
No, you have a court order. I mean, it's a court order. What you're just basically going to say, well, I don't consent to the magistrate anymore because he did a court order for me to appear.
Because he's
I have
not letting
all
me
these
win.
issues that I can't leave behind and I can't handle it. So I do not consent to abide by the order or the magistrate. And so I'm excused. No, it doesn't work that way.
I'm excused. I love that. That's what the motion says. The motion says, hey, I don't consent to you, so I'm excused. Oh man, this guy. I'd like to know someone I went to high school with him. So what was he like back then? The hearing in this case was noticed nearly 3 weeks ago on March 14th. I'm on the wrong page. Thus, defendants counsel had more than sufficient time to make travel arrangements. Moreover, defendants counsel had ample time to file a motion seeking a continuance of the hearing if there was a true scheduling conflict. Instead, he waited until the 11th hour to allege, quite dubiously, that he has a scheduling conflict. Ooh. You're very dubious in your filing.
I'll tell you.
That is despite the fact that since March 14th, 2025, Defendants Counsel has filed plenty of other documents. See documents 100, 104, 105, 111, 112, 114, 15, 16, 17. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9. I hate Dan Davis. How you doing, buddy? Sorry, I got caught reading Angie and Bad Duck. Hey, Volstorm, how you doing, bud? Because the defendants counsel has complained about needing to travel to Florida for this hearing, the court would point out that defendants counsel chose to handle a case pending in Florida. That's what you said earlier. Thus, he should have anticipated traveling to Florida for court appearances.
Especially in federal court. Yeah.
Right. Stating that because the parties chose to appear in this district, knowing that it was across the country, they should expect to appear in court as required. If counsel did not want to incur the cost and spend the time to travel to Florida for court appearances, then he should not have entered an appearance in this case. Lawyers from across the country regularly appear before this court, and then the court sets a hearing. Those lawyers get on a plane and attend the hearing. That is part of the deal when a lawyer decides to take on litigation in a far-flung jurisdiction. I mean, again, this isn't rocket surgery, you know. This is
robotic surgery or some.
right. I mean,
yeah, I know this is bad. I know.
I took the job 3 hours away, so I have to drive 3 hours to get there.
Mhm.
Finally, the court would be remiss if it did not address defendant's counsel's claim that he fears being arrested if he attends the hearing tomorrow. Absurd. So I read that and I was like, which is another sentence here says, if he doesn't appear, he will be held in contempt.
Well, he'll make it at the time of the hearing, because you know what, this could be just some stupid stunt, and then maybe he'll appear.
Oh.
But I don't know that.
What do you think, chat? Think about that. What if we're playing make believe, right? What if this was just a stupid stunt? He's like, I traveled all night by train and bus and
you
bicycle.
put the burden on me to be here, and but I don't know that to be true. I mean, we don't know. I'm just speculating.
No. Well, I mean, it's fun to do that. I mean, everything else in this thing's make believe. This isn't real life, right? I don't think so. For the reasons above, defendant's notice of defendant's counsel's inability to appear April and request to decide motion number 96 and show cause based on 115 is denied. So ordered the second day of April 2025.
Yep. So the judge is just going to conduct the hearing. And if he's not there, then you'll know there'll be an order out tomorrow about what the remedy or what the sanctions are, if, that kind of thing. Wow. Yeah, it's kind of bad.
That's
it makes lawyers look bad.
Right. I mean, it really does. It's
and you don't take on a case in another state and then pull shenanigans like this.
No,
because it really is a shenanigan. Because if he was really having some scheduling conflict, he would have written a declaration under the penalty of perjury saying, I have these obligations, blah, blah, blah. And he's not doing it under the penalty of perjury. And he's blaming the judge for a lot of things, which, I mean, it's just not cool.
No, it's not.
And as far as an appeal, so somebody was asking, like, can he appeal this decision, like an emergency appellate thing? I don't think so. I don't know what the appeal would be based on, like a writ to the federal appellate.
If it's a magistrate, okay, let me ask you. So the magistrate, so you have a federal judge, and the magistrate is kind of works pretty much for the federal judge. Just keep things simple. And they don't hear, they hear most cases, but there's usually, there's certain cases they don't hear. I forget. Anyway, if you have a problem with the magistrate, would you appeal to the judge, the federal judge, or do you appeal to the district?
Well, it would be a writ of some sort, okay. Or some kind of an ex parte to the district judge, the one that's going to hear the trial, I guess. But I don't think that there's any basis. I'm not sure how. I'm trying to think. I'm not sure how it would work, but there's no basis. He provides no basis for his not appearing at the court. I mean, there's no basis. He doesn't sign anything under the penalty of perjury. And it just, there's no.
Well, he says he's scared he might run to
shit. What the judge didn't address, and here's what I'll tell you, what the judge didn't address is the issue of having YouTubers at the court that are ready to attack him. The judge didn't address that in his order. So I'm sure possibly that this guy, Bruce Maskin, or whatever his name is, is going to bring that up at some point. Like, you didn't address that part. You just addressed the fact that I was going to be arrested, and Yeah.
So people, when I talk to people that are interested in this, they ask a question like, like they want to rationalize what the judge will do. Like, I was like, you don't know. My personal thing is don't try to rationalize what a judge will do. They should always just follow the law, and they don't really take a feeling into it or think that this is silly or whatnot.
Mhm.
But I will ask you this. Now that I said that, let me ask you, what do you think the judge will do though about like, so he didn't address the YouTube thing.
Mhm.
Is that going to be something that I mean, it's like,
Well,
I guess what I'm asking is like, I kind of think it's like, maybe the judge's the YouTube thing, it sounds made up. It's not a legal, it's not a, and there's no
well,
threat there.
if he was really worried about it, he would have signed it under the penalty of perjury and filed a motion for a protective order if he was really worried about it.
Yeah.
So he could have addressed that, and by doing that, but you gotta test when you're making excuses why you can't complete something or why you can't comply with something. You got to have something under the penalty of perjury. You can't just, or you have to be in court and tell the court personally, there you're making representation.
Yeah.
Otherwise, it's just a written document. There's no, if you lie, that well, I wasn't under the penalty of perjury. Yeah, he didn't swear under the penalty of perjury. So it's not. I mean, that's why the court says dubious. You're dubious. Because that happens. And so, like, same in the Koberger case, when the defense tried to extend discovery, there was no reason for it in a declaration. Like, I need the discovery date continued because of such and such and such and such. I declare under the penalty of perjury that the foregoing is true and correct. And so the judge denied that continuance, and everybody's like, why did you deny it? And it's because there wasn't sufficient cause, good cause.
Yeah.
And good cause comes from an explanation under the penalty of perjury as to why you can't comply or why you need a continuance.
I don't know. I'm like,
but it's not that hard. These people, he's just making it very difficult.
Yeah, I mean, well, the judge even said that. The judge said this is a two attorney, one person deposition case. It's a deposition case.
And he's quoting the judge. You think you'd want to get that quote right.
Yeah. What's going on? You need Yoli to come to Discord. Have you not been back there when she comes in, Freckles?
I've been back there.
Yeah.
Yeah, I can come sometimes. Yeah.
That's there. It'll be a hardship on his kids who are 23 and 15 to fly to Florida. Yeah, they get scared if he leaves.
Yeah, no, these things are just, and to bring his kids into it and this and that, it's just really it's not professional at all. I mean, this whole thing, it's just not professional at all.
I'm sorry.
Two attorneys in one cup. God. Are you okay, expert? He thinks Zoom is an airline. Oh my God. Did you see that one? He thinks Zoom is an airline.
Oh my gosh. I'm sorry. And this Zoom is an airline. Yeah, well, I mean, that's true. That's true. It's I mean, yeah, I got broken.
Funny.
Sorry. I saw that it went through my head twice. Oh,
Zoom is an airline. That's classic.
Well, and you know what's funny about that is we talked about the use of Zoom and everything since the pandemic. It's not I don't know, it doesn't feel the same.
Actually, I'm grateful for it. I mean, I don't have to be driving to LA. I don't, you just roll out of bed and put some makeup on and appear,
Yeah.
I'm actually grateful for it because I don't have to drive to the court just for the court to tell me, okay, your trial date is on such and such date. Okay, thank you. Bye.
And that's great. I mean, that's what technology is supposed to do.
Mm.
You watch some of the if you ever see MG Law, he does a lot of the he always loves to find those sovereign citizens cases when they go for a judge, and they're always on Zoom, and it's crazy watching some of them. It's like they don't realize that they're being watched, and they don't. They're sitting in their bed or whatever, and they're not taking it as a right now you're in a courthouse.
You're in the robe.
Yeah.
And they don't take it as, oh God. There was one when the pandemic started, there was a attorney that appeared on Zoom and he had a cat filter.
I was just thinking that when you started on that. Yes.
Hilarious.
And he goes, "No, Your Honor, I am not a cat. I'm not
a cat. Your Honor, I'm ready to proceed."
Oh, it did.
And then the judge is like, "I think you have a filter." And then he's like, "My assistant is trying to take it away. I'm not a cat. I'm ready to proceed." And the cat is God, that was hilarious. So many things happened in that time frame when COVID hit that it was like you'd have a judge on Zoom or whatever video, and he'd be alone in the courtroom, like you can't see anybody but him. He's wearing a mask.
Yeah.
And then the janitor has to come and clean the speaker or whatever. And then he comes in, and then it's like this. It was like being a Charlie Brown and that listening to the teachers. It was like, oh my God, like, sorry, Your Honor, we can't hear you. Your Honor, I'm sorry, you're muffled. And it was just, but it got better. So,
well, even today, courts, they have poor sound, and that's the thing. Broken Baker, he's consistently about it. People that ask, about doing YouTube and stuff, it's like, make sure that your sound is good. And I think that's very important, but I think that's for me though. Like, I'm like how he is. We spend so much time on stream and everything that it drives us nuts. Like background noises on somebody else's stuff. It's insane. You just go nuts listening to it. But that is the thing with the courts though. The speakers suck. The video, the cameras, the angles are never right. It's weird. I don't know if I like it. But hang on a second. Here we go. I have a question. Hope it wasn't already asked. If he doesn't show tomorrow, aside from these sanctions, do you or experts think the judge would issue a warrant for his arrest? We kind of talked about that.
Yeah, we did. And the judge could issue an arrest based on contempt of court, a bench warrant. Mm-hmm. Well, that's what they call it in state court. I don't know what they call it in federal, but it's a bench warrant. So if you don't show up, like, for example, here in California, like if there's a minors hearing, like regarding a minors settlement, and you're responsible for the funds for the child, they will sometimes, if you don't appear, like let's say there was a calendaring error or something and you don't appear and it's a minor, they'll set a bench warrant for you. And it just means you need to file a declaration as to why you didn't appear. And then the court sets a hearing, and then you explain to the judge why you didn't appear, and so on and so forth. But it's a bench warrant because it's a warrant. But it's called a bench warrant. So I'm sure there's something like that in federal court that they could issue a contempt warrant or something. I'm not sure what it's called, but that could be something possible. That's possible. Or, they could revoke his pro hoc BJ status. But I think the defendant would need to be heard on that because it's not like in Karen Reed, for instance, there was an issue about whether they were going to revoke Alan Jackson's pro hoc vice appearance. And the judge had a conversation with Karen Reed about that. And Karen Reed still wanted her attorney, so she didn't revoke the pro hoc vice status. So, yeah, in federal arrest warrant. Yeah, it's probably an arrest warrant. Yeah. Maybe there's no such thing as a bench warrant.
Well, let me ask you, what's what's the? Oh, hang on, real quick. Bad duck. Why don't elephants ride tricycles? They don't have a thumb to ring the little bell. I like that. I get that. Bad duck. I said to my QAnon all the time, like, "Oh, you can't open the door because you don't have thumbs." Ha ha. Because she's mean to me, and so when I can pick on her, I just realized, okay, so yes, me and my dogs. Well, my one dog, she picks on me and I pick on her. Maybe I just need to stop talking right now because it sounds really bad. You don't understand it unless you have a complete QAnon. Sorry, thank you, Bad Duck. I like that. So what do you think? I mean, it's okay. Well, actually, no, hon. I do have before I forget this one. Sorry. If he takes away the pro hoc visa, so that means you have to start that over again, right?
Well, I don't think he can take it away without talking to the defendant, is what I'm saying. So
I see. Yeah.
He probably won't. Yeah, he probably won't take it away at the hearing or revoke it until he'll probably set another date and order the defendant to appear so that he can talk to her about this issue. So, you know, the defendant is the party to the action, so he doesn't want to prejudice her, although at this point she's already being prejudiced by somebody who is not complying with the court order. But I think he will not revoke it tomorrow, but he'll probably say, if Bruce doesn't show up, and he may show up still, so we don't know. So the court isn't going to make any kind of order until the hearing. The case, Angie's asking Yoli, would the case be tossed for his actions? No, it's the plaintiff who has the case, right? So the plaintiff's case would proceed. It wouldn't get tossed because of his actions, but the defendant could suffer terminating sanctions, which means that there's going to be a judgment in favor of the plaintiff. But I don't think that's going to happen yet.
If he replaces Bruce Maskin, there's the defendants, whatever everybody's calling him now. I've heard everything triple B. I mean, there's just names for him. Whatever it is, the latest thing is. Oh, hang on. Look at this. Hold on. I got distracted. You guys saw this. Kay does his Baker as Yoli on his stream to make people think he is smart. K-Dubs, I did the same thing.
He's funny as hell.
I did the same thing. Isn't he great? So if he says, okay, Bruce, you're gone. Bye. You're not representing these people anymore. Bruce gets to go to Applebee's or Chili's, whatever. Chili's, I think they got the 2-for-1 drinks. And he gets to have a celebration, eat some baby back ribs, all that stuff. What happens then? You replace him. The replacement attorney comes in. What does that do as far as time? And
the replacement attorney has to have time to get up to speed with the case. So that's going to be allowed. But I mean, they're not going to appoint her. They're not going to appoint the defendants an attorney. I mean, it's not a criminal case or. So she would have to find another attorney. So it does. I mean, if you think about the defendant, and I know a lot of people don't like the defendant, but it's still a person, right? So it's a litigant. Right. So the court has to consider the litigant. She's being sued, or the defendant's being sued. So it's just a shit show for the judge. I mean, he's got to deal with all this stuff. You know, he has to take everybody into consideration.
Yeah.
He has to be fair and impartial. And it's kind of hard, you know, when you have litigants that are putting out their dirty laundry all in front of him, which is highly irrelevant. The only relevant thing is the defamation and whether or not the defendant defamed the plaintiff. Whether or not there are YouTube streams about it, people covering the case.
Yeah, it's just at the end. I mean, was it the thing? God, what was it? I heard this. It was maybe it was like criminal procedure. You know, there are three things that matter in a case: the facts, the facts, the facts. And that's
Yeah, and then how the law applies to facts, and
yeah,
you know, you just stick to the facts, the elements of the case. You know, instead, he's talking about all these YouTube streams and putting links. And okay, people have the right to free speech. I mean, you can't control what other people say, you know, and whether or not somebody is filing a lawsuit just because they want to make content. I don't know. I don't know that there's any. I mean, what, RICO or some? I mean, that's failed in most cases. But you know, honestly,
failed here too.
It really doesn't mean anything. It won't. It doesn't mean anything. I mean, if there's statements by the plaintiff that he's only doing it to harass, to, you know, do things like that, you know, I don't know if what he's doing. But if there's evidence of that, then the plaintiff might be seen as a vexatious litigant, because they're the ones bringing the action. But with regard to this Bruce guy, he could also be seen as a vexatious litigant as well, because he's putting things out there that further perpetuate the YouTube world.
I would like to know. Yeah. See, and he keeps saying that it's the plaintiff that's the ones doing it, and it seems like he's. I mean, the thing was we read last time. He files motions. He does it in everybody's name instead of just doing one filing. Yeah. You know, it's I don't know. It keeps going on. Hang on real quick. Hey, Mr. Coop, how you doing, bud? I was talking about you earlier. Someone asked me about you, and I was like, yeah, you got to start doing a lot of paracord stuff, I think, over there, which is, that's cool stuff, by the way. I wish I could, I almost said knit, but paracord stuff always seems cool, and I can't tie a knot. I have trouble tying my shoes, and I'm very jealous that his wife found Velcro for him. My wife just doesn't have that ambition, so she just lets me fall. And then Volstorm, yes. So, okay, here's the thing. So, Rennie says, can the Florida attorney that's sponsoring Bruce be made to handle the case? And as Volstorm says, Stark sponsored Bruce.
Yeah, that's possible. But at the same time, the court is probably going to want to talk to the defendants to see if and I'm
okay with that.
Yeah, because you can't deprive someone of their right to have their own attorney, whoever that may be. But if the court does talk to the defendant, the court could say, and I think it may have happened in the Delphi case. I'm not sure. But the Delphi case, she basically said, you guys aren't competent to represent the defendant. So she removed them from the case, which was a little strange.
Yeah, that Delphi case. I got into it way too late. There's so much weird stuff there, but
I don't know much about it, but I do know that there was a court ruling something like that. This is hilarious.
Bad Deck says, what do you get when you cross an insomniac, an agnostic, and a dyslexic? Hang on, wait, and agnostic. Yeah, okay, I got that one. I didn't know what that was for a second. I was like, I've heard that before. I know now. I got it. Okay. So what do you get when you cross an insomniac, an agnostic, and a dyslexic? Someone who stays up all night wandering. There's a dog.
It's hilarious.
I love that one. That was really good. That was really good. Sometimes he says, I don't know if they're jokes or statements because I don't get the punchline if it's a joke. And that's not, you know what? It's nothing on him. That happens to me a lot. It happens to me a lot. So, oh, that's why K-Dubs came over because you're here. It was just me. She's like, no, I'm not coming over there. I like logical minds. Let's see here. I have not noticed anything younger. And then, get the Skechers slip-ons. Thank you for the advice, Paula, instead of Velcro. Yeah, we skipped that one, Coop, because there are two others out, but
It was just rambling.
Yeah, it is crazy. There's another thing I had right there. We're talking about left me. Do you have any more questions? Yoli, do you have any more thoughts?
Just it's possible that Bruce may appear tomorrow in court.
That'd be wild, and I do like that. I'm glad you said that because that's outside the box thinking, and I like that. That's my.
He might appear, and then whine about appearing, or the judge is going to decide what to do, and he'll put out an order about what he's doing tomorrow. Because he's pretty good with these orders. He puts them out right away. And yeah.
What I'll be interested in, because he said for both attorneys to bring their checkbooks. So,
yeah.
I mean, that'll be interesting.
Because, there's one thing. I mean, they're both. I mean, it's Bruce that I see that is engaging in the most, but they're both going at each other. And it's something like especially in federal court, you have to meet and confer before bringing motions. And you do need to set forth an affidavit or declaration that you met and conferred, and we talked about this, and we couldn't come to an agreement, and so I'm filing this motion. And so sometimes you don't have to meet and confer for certain motions. I think there was one that they said that, I don't know. But anyway, it's they're attaching all these emails and how unprofessional this person is and how unprofessional this person is. And actually, it's more taking up the court's resources and time than anything. And so, it's very frustrating. And, you try to resolve your problems. And if you can't resolve them, then that's when you get assistance from the court. But you can't just, bring everything to the court and then try to put in some other stuff to make the other side look bad,
So, I mean, that's one of the things I think we should, tell everybody. Make sure that you realize that when you're litigating, you don't go in immediately trying to be as troublesome and burdensome as you can be on the other side. Because I mean, you have to zealously represent your client, but at the same time, though, it's what it should be is that everybody's looking just to be made whole, and whereas, I don't know. It's just, it's so absurd from anything I've seen.
Yeah. And if there's a legitimate dispute, then that's when it goes to trial. But, you really, these things nowadays with YouTube, that it's about, I don't know. Yeah, it's, it might change, because there's other cases like this that I know of that are talked about in other true crime, in the true crime arena and missing children. And, I think there's going to be law in the future regulating this, and because they can't take up the court's resources for things that, where they're not focused on what they're doing. I mean, it's like, any chance it's not the place where any chance you get to dig at the other side. You get to put everything bad about the other side. And so like in the Koberger case, there was a motion in limine, and an expert provided support for that motion in limine. And it was strictly to say that, they need these records because of such and such. And if the prosecution is hiding them, then that's misconduct or something like that. And people are like, well, he didn't say that Koberger was somewhere else. I'm like, okay, so it's just limited to that motion in limine. It's not proving up the whole case or, going on. And, it's, you have to be very focused, because nowadays less is more. Judges don't have time to read everything.
No,
they don't have like the research attorneys at their disposal, or at least not in California. So, you got to make it simple.
That's one of the things I was always told, like, make sure, everything that if a judge asks an attorney, doesn't matter what side, for law on something, a case, or, basically like, because there's maybe a couple of judges kind of took liberty of having the attorneys do all their legal research for them. And it's like, you always made sure that you had the research there that they wanted, because they didn't have anybody else to do it. They're sitting there doing it all themselves. And that, it's, I don't think anybody, I couldn't imagine in a place where you live, what it had to look like. I don't know, maybe you're paperless now. And maybe it's paperless everywhere now, but like going back into the court clerk's office and just looking at all the files. I remember first year's summering, I had to finish building, right? That was supposed to be learning law. And I had to finish building the attic, put flooring down, because the law office had so many files, they didn't have anywhere to put them. And it's just, there's just so much paperwork that I don't think people understand. You don't make favors by adding to the stress of the judge.
No, and judges here in California are stressed. They're shorthanded after COVID. It just slowed down. Everything slowed down. It's still catching up, and even still, there's e-filing or electronic filing of documents. But sometimes, like in LA, they're electronically filed, and then you get a response that it was received, and then you go to court, and the judge is like, I didn't receive that. Let me see. Hold on. Let me look. And they look and they say, well, I see that it was filed, but I don't see the actual document. And oh my God, it's
crazy. Hey, wait a second. CJ, this isn't Wednesday, is it? Oh,
yes, it is Wednesday.
I usually do a coin pusher Wednesdays. I thought it was Tuesday.
For some reason, I thought it was Tuesday too.
That means tomorrow's Thursday. Well, that's not gonna do. Tomorrow's gotta be Wednesday. We're gonna make tomorrow Wednesday. It can't be Thursday. I got stuff to do. I need an extra day of stuff to do. Yeah, that's just not right. That's not CJ. That's not gonna work out. We're gonna have to change. Today's not Wednesday. Okay. Holy cow! I had no idea. Like, I really did not. I'm sorry. Oh wait, today's Thursday. She's behind.
Thursday. It's Thursday for him.
He's in Australia.
People like the coin pushers.
I know. Well, I might wake up at 2 a.m. and be like, hey, well, why not? Let's just see what happens. All right. Well, listen. If there's nothing, you don't have anything else to add, we'll get on out of here.
It's like people need to keep it civil when they're litigating.
Tomorrow will be we'll find out what's happening, and so we'll just take it from there, I guess. But all right, thank you so much, Yoli. And then guys, please remember her link's up here at the top. Let's get her. She's how far are you away from 1,000 now?
I was like 908 the last time, 908.
Well, hopefully we got you a little bit closer. Every little sub counts. Trust me.
Every video I do, I get a little bit more subscribers, but it's a coworker case right now because I work and I don't have time to cover anything else. But I do have time sometimes to come on this case.
Well, I love it. I love that you're here, and it's of course, hang on a second. Somebody just sent something to me.
Oh, 916 now. Wow.
So anyway, it's I like having you on here because I like having both of us. It just I have nobody else to talk to about this stuff. Okay, I'm sorry. Oh my gosh! All right, I'm sounding like an idiot. I've been sounding like an idiot all night. I need to take my no.
Actually, this is a civil case, so that's what I do is civil law, but in state courts. I did federal court before in the past. But
Well,
anyway,
you have the experience of federal court, and you understand the nuances of it.
yeah. And you don't
I
want to
didn't
mess
realize-
around with federal court. I mean, that's you don't.
Yeah.
Federal judges are appointed for life, and if you're going to be working in federal court, you don't want to piss off judges because you'll run into them again.
I think you're officially one of us. So, anyway, she is at the top of the chat, Mr. Coop. So, all right, guys, thank you so much for hanging out with us, and thank you, Yoli. And I wish I could dance us out of here, but somebody decided that it's a copyright thing. I've been doing Sweet Brown for 3 years, and now they're trying. I'm like, how do you get any copyright on this? Anyway, it's stupid. It's what is this thing called? Tube yard?
0, 1, 2, 3. Let's get started.